Hey, welcome back. This is Terry Jordan Adams of Sued by the Debt Collector, suedbythedebtcollector.com. What we're going to do today is we're going to cover some more FAQs, some more frequently asked questions, because we always have questions, and that's a good thing. Anyway, but before we get into that, I just kind of want to share kind of some of the focuses I've had in my life. What I've decided to do is create some five five pillars for myself. And what those pillars look like is these pillars are designed to make improvements in my life. Maybe get reorganized or better organized, making sure that I'm building relationships and maintaining relationships, working on my health, faith, and working on the business, so that I can create a bigger impact for the community. So, really quickly, if I can encourage you, come up with 5 pillars that maybe you can work on every day, because what I realize is small steps make big impact. The golfer doesn't need to make a power swing in order for it to go far. All he has to do is just adjust his swing, millimeters, and it causes a bigger arch when it goes to get into the hole. So it didn't mean that he needed to add more power, just a small adjustment to create a bigger arch. So I encourage you to do the same thing and watch how your small contribution daily will begin to better your life and make changes, increase everything from maybe weight loss, just making small changes, drinking more water, less Starbucks, if you will. Anyway, so I just kind of wanted to share that's one of the things that I've been working on, and I encourage you to do the same. But without further ado, let's get into these FAQs. So, Jade says, or asks, original creditors versus debt buyers. Is the process the same when you respond to the lawsuit? Yes. The answer is yes. The process is the same when you respond to the lawsuit. Because once you get sued, it doesn't matter who it is, the lawsuit will tell you, first and foremost, how many days you have to respond before you get a default judgment. Okay, we're all about avoiding default judgments over here at Sued by the Debt Collector. So that's the first thing. But one thing that I really want to point out is it's not just the process from filing to trial, but it's also when you're responding to your lawsuit. That's a process also. Whether it's the original creditor or whether it is a debt buyer, you still need to audit that lawsuit for integrity and accuracy. It doesn't matter who it is. It doesn't matter who it is. You always need to audit it for integrity and accuracy. And why? Because just because they make a claim for something doesn't mean it's 100% true, 100% accurate. Okay? And you know how I feel. I believe you should always respond to a lawsuit when you've been sued. They put you in the worst case scenario, so you don't want to make it worse. You need to make sure you respond. I'm going to tell you that a million times, or every opportunity I get. You always need to respond, even if you are settling or attempting to settle, because they will leave the lawsuit open pending settlement. And if the settlement doesn't work out, or whatever, and they don't close that lawsuit, then you've burned up your time to respond, and they're immediately going to file for a default judgment, and we want to avoid that. So, to answer the question, yes, whether it's the original creditor, and I know you're thinking, oh, well, the original creditors, they have all the records. Yeah, they may have all the records, but did they submit supporting information for the claims that they're making in the lawsuit? So, integrity and accuracy to avoid a default judgment. Okay, thanks for your question, Jade. Leon asks, should I cite laws when I answer? Absolutely. If you have laws available to you, all that does is it strengthens your case. So the debt collectors, some of them have gotten pretty lazy. And even the original creditors are kind of lazy. They'll get the form and they'll just check the boxes. And sometimes those boxes don't have any laws attached to it. Okay? But with your rules of evidence, you want to make sure if if at all possible, whether you're disputing or denying or admitting, whatever your process is in responding to their lawsuit, you do, if it's available to you, want to use the law, because what it does is it strengthens your case. Now remember, they have the burden of proof, so by you saying XYZ law states this, they are not in compliance, because then not only do they have the burden of proof, but then they have to respond to the claim that you're making concerning X, Y, and Z. So you want to make sure that you use supporting information if it's available. A lot of times people don't, but I give you the greatest opportunity for success. So that's my recommendation. Okay. Thank you for your question, Leon. Alexa, okay, this is a two-part question, or sort of two-part answer. Alexa says, what is the fastest way to get through the debt collection lawsuit? What is the fastest way to get through the debt collection lawsuit? Well, Alexa, that's a good question. Okay, speed is one thing, but your part must be tactical. Okay, ideally the judge wants to push it through trial within a year. That rarely ever happens. One, if it even makes it to trial, and two, there's always a bottleneck. So unfortunately, the debt collection lawsuit is not a speedy process, but there is times where you will be able to get some relief or breaks in between the next action. But that was not where I was going. Original creditors, file it with a form. Okay, check the budget and they're supporting it. Okay, all right. I already talked about how the original creditors, they check off the boxes and stuff. But here's the thing. With the lawsuit, the thing that needs to be addressed with speed is the amount of time that you have to respond so that you don't get a default judgment. We talk about this. If you're in our location, it's 30 days. I have another client, they're in Arizona, and I believe it's 20 days. I want to say Illinois, I could be wrong, but somebody had 10 days. Okay, so that's where speed matters. Okay, but here's the thing. You don't want to answer just to answer quickly. That's not the game. You want to answer quickly, but you want to answer tactically. You want to be tactical in your answer, because if you just hurry up to get it done just to get it done, then it's going to prolong the process and you're not going to have a chance to take it back. So you want to answer well. You want to create your defenses, and you want to make sure you're, disputing anything, any inaccuracies. You gotta, unfortunately, what it's going to take is you're going to have to set some things aside in your life to get through the process. If you have 30 days, well, that's a sufficient amount of time for you to whittle away at the process. But if you're in a state that's, only got 10 days and you didn't reach out sooner than, let's say you got served and 4 days have already passed, well, you've only got 6 days to get through the process. So You're going to have to set some things aside. You're going to have to close the blinds, turn on the light, close the door, keep everybody out. You're going to have to dig in. But you want to be tactical in your answers. Okay? Not only that, but there's stages to the lawsuit, beginning with them filing. You know, they file the lawsuit, and then they serve you, then you answer, then you serve them, then the judge schedules a status conference so that he can check to see what stage you guys are at in the lawsuit, you know. And then there's the next, you know, so there's different stages in the lawsuit. So it's a marathon, it's not a race. But the most important thing is you meet your deadlines. That's the part where you're going to be hard pressed on time. So you want to make sure that you don't lose sight of that. Okay? All right, next question. Alexa, thank you for your question. John says, when I answer the lawsuit, how do I file it with the court? Well, when you answer the lawsuit, there's actually different ways to file it with the court. In my program, if you're enrolled in the program, the final module actually walks you through the process of how you get it filed with the court, you know, copies and how you get them served, and then proof of service. The module in there actually gives you a step by step. It shows you exactly what you need to do. You don't even have to think hard about that. But if you are not enrolled in the course, and I hope you are, because if you are, then I am feeling really good about your chances of winning. I'm just saying. Anyway, if you have not enrolled in our program, then there's different ways that you can file it with the court. You can actually go to the court. You can always check the self-help website, and it may be a little difficult to sift through some things, but it should be there. Then you want to make sure that you have enough copies. You need at least 3 copies. And I say 3 because 1 copy is going to stay with the court. 1 copy you're going to keep for your files, and then the other one, they have to get served. And you can actually serve them before, you can have them served before you go to the court. But what I like to do is I like to have it stamped. That's just a preference thing. That's probably me being a little OCD. So, but either way, that way you've got a stamped copy at the court. You have a copy of that's stamped, and they have a copy. But they can always, and you can always, once the court gets the images and everything uploaded on your case, then you can always pull a copy if you need to do that. Also, during COVID, our courts were closed. I'm sure all the courts were closed, and the debt collectors were still filing the lawsuits electronically, banking on the defendants, consumers, not to respond because they didn't know how. But there is a email. There was an email that people like me could email my response to, and it would take about a day or 2 to get recorded before, and then it will be posted on your case. So, but you know, I don't know if that's every court. I don't know if it was because it was COVID, the circumstances were different. I don't know. But also there's companies. There's not process serving companies. There's legal document companies where what you do is you can upload it to them, you pay for their service, and then they submit it electronically on your behalf. Okay, and then you can get a confirmation and everything. I know sometimes some of us are really, really busy in our lives, and so that is an option. If, in my opinion though, if you are up to the wire and it may take them a day or 2 for them to get it, you know, electronically filed with the court, and if there's any glitch and you don't get it in on time, and you know, if you're up to the wire, Just take it in. Save yourself some anguish. Just save yourself some anguish. That's my recommendation. So, thank you for the question, John. Next question, Nayeli. Nayeli says, do I still have to appear in court after I submit my answer? That is a loaded question. It depends on your jurisdiction. Like I said, whose question was it? In Alexa's question, there's stages to the lawsuit. They file it, they get you served, you respond, you serve them, then the court, they schedule a status conference. Well, the status conference is the first communication that the plaintiff and the defendant has with the judge, also known as the case management. So the goal is get your answer filed with the court and get them served. Now, the next thing is you have to know what your paperwork says, because in different states it says defend and appear. And so some of them don't give you an immediate option. Some of them say, you know what, get it filed and you have to show up on this date. So you kind of want to be aware of what the different jurisdictions are saying. You know, I had spoken to I want to say somebody in Arizona, and they were required to show up. So I think somebody in New York was required to show up too. Anyway, with all of that being said, you have to understand the instructions of the lawsuit. If you don't respond within X amount of days, you could get a default judgment. If you this, that, and the other thing, you need to show up on this day. You have to respond to defend yourself. And in some states, they have what they call a citation. We don't have citations here, but be aware that they do exist depending on your state. So you make sure you read the paperwork and the instructions. Okay, so that and the deadlines are going to be your ticket to staying out of a default judgment. If you don't follow the instructions, if you miss the deadlines, then you're putting yourself in danger. And we don't want you in danger. We want to keep you from hurt, harm, and danger. That's it for my FAQs, but I am working on getting a process server, because what I'd like to do is I would like to interview process server, and I want to ask questions, and I want him to tell us what the process is, and I want to talk about what sewer service is. I want to talk about ethical serving, you know, that kind of thing, not just throwing it on somebody's step and calling, oh yeah, they've been served. You know, it was kind of crazy when I was served with one of mine, and they filed it. They said they put on the paperwork that it was a black guy and a white woman. Sorry, I'm not white. But so that particular process server lied. But so I'm working on getting a process server to see if we can maybe get some good intel for, you know, what's right and what's wrong. But anyway, so this is Terry Jordan Adams of Sued by the Debt Collector, suedbythedebtcollector.com. If you have been sued by the debt collector and you need help but don't know where to begin, visit us at Sued by the Debt Collector. My card's crazy. Visit us at suedbythedebtcollector.com. And if you cannot afford an attorney, if an attorney's not in your budget, we got you. Make sure you visit us at suedbythedebtcollector.com. And don't forget, get your free case evaluation. Okay, what we do in this case evaluation is we talk about what stage your lawsuit is in. We talk about what your options are, and we come up with kind of a strategy for what to do next based on what your desired outcome is. So, but you know what? You got to text me 877-505 0618 and put consult in there, and it'll come to me. Make sure you get on the calendar, and let's talk about how we can help you to avoid a default judgment and create a strategy for you. Okay? Anyway, if you have any questions, if you have any comments, if there's anything you would like me to cover, make sure you drop me a message. Leave it in the comments section. Okay? And let's continue to keep rolling, and let's keep these resources available for you. All right. Hey, this is Terry Jordan Adams, a Sued by the Debt Collector. Let's go, Slayers. See you next time.